I, Dr. Gurpreet Kaur Garewal, Assistant Professor from Department of Biotechnology, welcome everyone to today's workshop on the basics of patent, organized by Department of Biotechnology, Kanya Mahavidyalaya, Jalandhar, an autonomous and heritage institution ranked #1 in
I'm sorry,
Punjab and
Gurpreet
has
ma'am, I'm
top national
interrupting.
ranking.
Actually, there is something else visible on your screen. It's about training PAE 2022.
Actually, Monica ma'am has shared her screen.
Okay, fine.
Okay. So it's ranked #1 in Punjab and has top national ranking according to the survey by India Today in 2019, 20, and 21. So I extend warm welcome to resource person for today's workshop, Mrs. Monica Sharma, who is a patent facilitator at Indian Patent Office in Startups Intellectual Property Protection Scheme launched by Government of India. So I'm thankful to our worthy principal, ma'am, Dr. Professor Atima Sharma Dwivedi, for her encouragement and providing platform to expose students to the world of intellectual property rights, as that encourages students to innovate. So before we start with the session, a brief introduction about Mrs. Monica Sharma. Mrs. Monica Sharma is a registered patent agent, patent facilitator at Indian Patent Office, that is called IPO in New Delhi, under Startup Intellectual Property Protection Scheme launched by Government of India. And I just want to mention that she's also a recipient of Women Scientist Scholarship Scheme, so which is facilitated by Government of India only, and that is awarded by Technology Information Forecasting and Assessment Council from Department of Science and Technology, Government of India. So she is a intellectual property rights professional having experience of 3+ years as a patent scientist at Khan and Krishme Attorney at Law, which is a patent law firm dealing basically with foreign multinational companies. She's a member of Asian Patent Attorney Association. She has 2+ years of hands-on patent case filing experience, also experience in patent searching, drafting, prosecution, hearing, opposition, and also IPAB appeal filing, litigation, and design case filings. She has her expertise in patent search using EscapeNet, USPTO, InPass, Google Patent, and of the WIPO, that is World Intellectual Property Organization, Patent Scope. So after her professional introduction, I just want to brief you about her academic introduction also. She's master's in pharmacology from Pandit Bhagwat Dayal Sharma Postgraduate Institute of Medical Sciences from the Central University. She has advanced postgraduate diploma in clinical research from Catalyst Clinical Services Private Limited. She's bachelor's in pharmacy from PDM College of Pharmacy, that is Pandit Maharishi Dayanand University, Rohtak, Haryana. So apart from this, she is also a degree in law. She also has attended 2 distance learning courses organized by World Intellectual Property Organization Academy, Geneva, Switzerland. She has attended many seminars and trainings on IPR. I just want to just mention of one of them was organized by Japan Patent Office. So I know her from since 2012 when she was there in CSR IGAB Delhi for her master's dissertation. So welcome, Mrs. Monica. So now we can start with your uh, workshop and talk.
Yeah, hello. Thank you so much, ma'am. And good afternoon, all. Now we shall start our patents presentation. Please wait.
Monica ma'am, would you like to switch on your camera?
Should I? Yeah, wait. Yeah. Yeah, so thank you so much for the opportunity. Today I will present my all the views and regarding the basics of patents. See, first of all, I will explain the power of patents, that how powerful is a patent could be. I will give brief introduction about patents, and then we will start with the requirements and why do we file and why do we need patents. Further, we will understand what to do if you have an idea. You should go for the publication or you should go for the filing of patents. Then we will see the types of different patent applications and those inventions which cannot be patented or cannot be patentable under the Indian Patents Act. And then we will see a practical overview that I have learned during my practice at the law firm, and I have worked at the Indian Patent Office also. And on the basis of that, I will give a brief overview of every process. Then how patent is different from other IP forms. Now, so first of all, I will discuss regarding the power of patents. See, everybody knows, we all knows that what are patents. Patents is in simple form, it is a creation of mind. It is a creation or intellectual power of our mind. So suppose we got an idea, any idea stuck in our mind, then that idea should have some utility and non-obviousness so that we can patent it and in return we get rewarded with the royalty. So recently, IPO has published BioIcon IP story. I hope we all know regarding this, the biotech queen from Bangalore, India's first lady of biotechnology, the mother of invention. These all the three tags are given to her by WIPO. Any guesses who is she? Any guesses? She is Miss Kiran Majumdar Shaw. So, what rocket science she has done? I mean, let us understand that how she became such a powerful woman. She has so in our country, she is very well known outside our country, and her main power was patents. Now let us see. I will brief regarding her story. See, she is the chairman and managing director of Bicon Limited. She was interested in brewing industry. During her education time, she was very much interested in developing brewing industry. That is related to fermentation science. But problem was that she was from a state of Gujarat, which prohibits alcohol. So we all know that if there will be more production of alcohol and more easier production of alcohol and you know women in the alcohol industry, that could be bad. I mean that will be like it is very difficult to go further in this field for a woman. So what she did is she started a small Irish company as a joint venture, and Bicon was born. This company mainly focused on enzymes production for industrial applications. And this enzyme was produced from papaya fruit, that is the papain enzyme. Then this Irish company sold its ownership to Unilever, and in 1998, Ms. Majumdar Shaw and her husband brought out the Unilever share. See, Ms. Majumdar has the basic motive was like, first, how she started her research. She started her research from the patents which were already existing in the domain. First, she started searching what all patents in the fermentation technology are available in the country. Then she started with their strategy, that what is the main technical problem that is lying behind. So what she did is they innovate and developed a plow factor. Plow factor is a cost-effective bioreactor which enables all the different stage processes involved in the cultivation and extraction of the microorganisms to be carried out in fully enclosed system and under computer control. So they're integral tool that BICE can use to determine which areas the company's research and development sector should focus upon. Example, this is how they gain initial access to the field of human insulin production. See, when she researched, she get to know that product patent on the human insulin. They noticed that most of the patented processes use industrial and baker yeast for the production.
Sorry, ma'am, just interrupting you. So would you
Yes.
like to share slides also, or later on you want to start with the slides?
Am I not visible?
Only the,
My screen is not
no,
visible.
only the first slide is visible. Slide not going on.
Oh, wait, please wait.
So you have to share slides.
Is my slides?
You
are
can
not-
do the full slideshow.
I did the full slideshow.
So there is
Please see.
an icon at the bottom. So you have to click on that to have a full screen view,
Yeah, I have done the full screen view.
because it is because we can see the slide at the sides panel also.
I don't know. It is should be shown.
Ma'am, press F5 key, it will make it full view.
Yes, yes, this is the button which you clicked on the screen just.
Is it visible now?
No. This is only the smaller view, not the slideshow view.
When I'm doing it on slideshow view, I have clicked on it.
You have clicked, but it is showing only the, not a full screen.
I don't know why. Please wait.
Ma'am, you can press the F5 key
F5.
on your keyboard.
Either you need to maximize the view, or
Should I rejoin? Should I rejoin?
So can you try to maximize this window? This is opening as only a smaller.
Yes,
maybe.
yes, yes. Please. I think I should rejoin once.
Okay, fine.
No worries.
Ma'am, could you share now again?
Yes, yes, I'm trying. Just sorry for the inconvenience. Is it visible now? Hello? Hello?
It's visible. Just make it full screen.
Ma'am, it is full screen on my laptop. It is on full screen mode. I don't know.
Okay. No worries. Okay, yeah, we can go like this also. Just please keep on changing the slides. You'll have to do that.
Yes, yes.
Actually, yeah. Okay, fine. Thank you.
Is it visible on minimized mode?
Yes, it is visible in a minimized mode, not a full screen.
I have done on the slideshow, and now it is.
Click on this icon.
I have clicked on this.
No worries, we can carry on like this. Just you need to change the slides.
Should I change the slides on the minimized mode?
Yes, you can change the slides on minimized mode also.
Okay. Okay. So here we were talking about the power of patents, where Ms. Majumdar Shaw has an integral tool by using which she worked in that area. She itself said that we noticed that most of the patented processes uses Escherichia coli and Baker's yeast. And what they developed is they started using Pichia yeast for the development of insulin. And this was a new and unique process which was not covered by any of the existing patents. So insulin can be easily produced. Insulin structure has been easily known with all the researchers. Then what was that rocket science that Ms. Majumdar? See, there was a problem with insulin that it cannot be transferred or it cannot be easily transported to the other countries in the form, in its natural form or in its effective form. So what she did is she prepared this insulin from Pichia yeast, and this insulin was very effective and it has more shelf life and can be easily transported. Ma'am, my slides are showing on your screen.
Yes, right now the power of patent slide is visible.
Yes, yes. So that's the power of patents. And so next powerful biotech woman could be you. So further, now let us see one more example of importance of patents. Anybody, we all know that ring pull cans in any of the beverages and drinks, soda drinks like Coca-Cola, Pepsi, and all these use these cans and bottles. See, these cans were also patented. An inventor who invented this ring pull cans has earned so much of money. Can you imagine? He used to earn approximately 1,48,000 per day, UK pounds per day, for the 20 years of his life due to the power of patents. What he did is, when he invented these ring pull cans, the Coca-Cola company approached the person or the inventor who invented this, but he refused to license the patent to them. Instead of licensing his patent to them, what he did is he asked them for an agreement regarding the payment per can. What he did is he asked for a particular amount or particular royalty on the sale of per can. So this is the power of patents. So now let us start with the introduction to patents. Here, we know that what are patents. First of all, patents is a right which is given to a person over the creation of his or her mind for a limited period of time in respect of a new and useful invention. Exclusive right to prevent others from making, using, offering for sale, and it is a techno-legal. Here, techno word signifies and what does this legal document signify? See, all these are techniques that how it has Coca-Cola company and Coca-Cola formula and all these things. Coca-Cola formula has not been patented, protected under trade secrets. So patents are the technique with the legal document. It is a document which provides us exclusive right to get the royalty. And patents are territorial rights. They are provided for 20 years. Now let us see here. There are three essential conditions that should fulfill by every patent, that is novelty, inventive step, and industrial applicability. So if we discuss here regarding novelty, so what is novelty? Anything which is new is novel. We can say that anything which is new is novel, but there should be an inventive step. What do we mean by inventive step? Inventive step is non-obvious. For example, if a drug is useful for treatment of headache, that we all knows that this drug is useful for treating headache. But if we can find out that that drug can be used for the cancer treatment, then that will be the non-obvious. So this is the second essential. And third is industrial applicability. See, whenever there is some technical problem, the main purpose of patents is to provide a solution to that technical problem. And this is the way we can innovate. See, if there will be no technical problem, then there will be no innovation. So if some problem or technical problem lies in the society, then there occurs the innovation to provide some treatment to that problem. So that is called as industrial applicability. Now further we will see invention could be a product or a process involving an inventive step and capable of industrial applications. So it means a feature that is not obvious to a person skilled in the art. So why do we need patents? We need patents as a commercial tool and to stop anyone from copying your idea, to gain marketing edge and licensing and selling our product. And in return, we get the royalty. Further, patents are to increase the valuation of your enterprise or value of your business. And it is a source of revenue if it is licensed. Further, why do we need patents? See, we know that what does the inventor do? Inventor discloses invention and the best his invention to the patent office. And in return, government or the Indian Patent Office grant exclusive rights for the invention to owner of patent for limited period of time. So that will be regarded as a reward to the inventor, and inventor applies to the government. And this reward is for the 20 years. Now further, what to do if you have an idea? See, what we do if we got an idea of some or preparing something or developing any new invention, ensure that it should not be disclosed in the public, and ensure that we should sign non-disclosure agreements with the party or the company or the firm with whom we are sharing our idea. Now we should decide countries we want to protect our invention. Further, now let us understand what is a provisional specification and what is a complete specification. See, provisional specification is that specification or that draft of the patent application where your invention is not yet complete or you are still working on your research. So if that is not completed, then what we can do is we can go to the patent office and file a patent provisional specification. And in the provisional specification, we will not disclose, we shall not be able to provide them whole research results and all the things which are yet to come. So this is the provision given by the Indian Patent Office for those researchers which have not yet completed their researches, but they want to protect their rights. Then after that, within 12 months, there is a 12-month period that Government Patent Office has given to file a complete specification after that provisional specification. Okay, so once your research is complete, then we can go and file the complete specification. Complete specification will involve what all the things will be involved in the complete specification. There will be your results and every extract with the claims. Clarifying the boundary of your invention. So Next is what all are the types of patent application. There are basically different types of applications which can be filed in the patent office. And first one is provisional application that we have already discussed. Second is complete application, and third one is divisional application, and fourth is patent of adhesion. Now let us understand here what is divisional application. See, as the name suggests, divisional application. Divisional application can be filed either by our own desire or the applicant's own desire, or if any objection has been raised from the controller from the Indian Patent Office during the prosecution. So during the prosecution or of our application, if there are two inventions within the same specifications, same complete specification, then the controller will object to those claims. And what he will say? He will allow us to divide our invention and subsequently filing a divisional application. And within that divisional application, we can file our division of our main application. The main thing is that the whole duration, that is the whole term of the patent, the first date of the filing. Then the last one is patent of adhesion. Patent of adhesion. Suppose we have a pen, and for a pen, if we have already got applied for a patent for pen body, and if that body of the pen has been under patent application, and simultaneously we discovered and prepared a cap for the pen, so we shall require that we should file an application for the cap also. So in this way, we file a patent of adhesion that will act as patent application for both the body of the pen and for the cap of the pen within the same application. That will be called as a patent of adhesion. Now further, ordinary application, when the application is being filed for the first time in any country. See, we can go directly to our Indian Patent Office and file the patent application for our national. That will be ordinary application. Then second one is conventional application. There are conventional countries. There are many countries where we want to file. If anybody desires to file their application by a conventional application, then they can go directly file the application in the different countries. But the priority will lie with the first application. Then the third one is PCT. That is the Patent Cooperation Treaty. What happens here is, if we simultaneously want to file patent in different countries, there are almost 153 countries under the Patent Cooperation Treaty of WIPO. And what we can do is we can actually file in one go. We can file in as much as countries we want our patent application to get filed. So that is patent PCT filing. Is my screen visible?
Yes, ma'am, it's visible.
So here it is showing the complete flow chart of the processing
Monica,
of the
ma'am, you
government
can
patent
zoom
office. Here what happens?
Zoom to specific, yeah, font size is small.
Now it is fine.
Yes, it is
Is it
completely
okay?
visible.
Yes, ma'am. Okay. So, application. Whenever we file in the government patent office, what happens here is within 12 months of the date of filing, we need to file our complete application. That is the complete specification, which will include all the technical details of our invention. Next type is PCT international application, and on filing the PCT international application, we have 31 months time period within which we can file in different nationals And then within 31 months, we can enter Indian national phase application. Third one is basic convention application. From the basic conventional application filing, within 12 months, we can file Indian conventional application. And then there will be a request for examination that we shall require to file in Form 8 within a specified time duration. We need to file a request for examination to the Indian Patent Office. What happens then? Then the examination of our application starts, and there the controller and the examiner will examine our application, and they will make a list of all the objections if they face any of the objections or want to discuss further any objections before granting or rejecting our application. So we will get an opportunity from the Indian Patent Office that the first examination report is in that first examination report, all the objections such as objections of patentability under Section 3 of the Indian Patents Act, and all such clarity issues or any specification claim drafting issues, there will be all the objections, and the applicant shall require to respond to the office action, respond to that first examination report within 6 months. So during this phase, there will be a request for public required to file a request for publication where the patent office will publish our patent application in the official gazette. There is an official gazette which is weekly published by the Indian Patent Office, which has applied to the Indian Patent Office are published, and from there we get if any pre-grant opposition. Pre-grant, as the name suggests, before the grant of the application, if there is any opposition or if there is any party which is aggrieved by the which wants to oppose our application, then there will be a chance for applying for pre-grant opposition. If any pre-grant opposition comes, then there starts proceedings regarding the pre-grant opposition, and if no opposition comes, then there will be first examination report and further response to office action we shall require to file. If all the objections has been complied by the applicant, then there will be a grant of the patent, and that grant of the patent shall further be published by the Indian Patent Office in its gazette, and there will be annuity payment which has to be paid by the applicant. And then if there is any within 1 year from the grant of patent, there will be post-grant opposition chance. If any post-grant opposition is required or any post-grant opposition comes to our patent application, then those proceedings shall start from this place. So this is an overview where I want to just brief out that how Government Indian Patent Office works. Now next is which inventions are non-patentable in nature. Under Section 3 of the Indian Patents Act, there are few inventions, there are few clauses which shows that how which all are non-patentable in nature. First one, I have briefed out some of them here in the point wise. First one is frivolous inventions or against natural laws. Frivolous means any dangerous inventions or which are against the natural laws are not allowed by the Indian Patent Office. Second is contrary to public order or morality. Anything which is contrary to the moral values or the public order, they will not be allowed or not be patentable under Indian Patent Office. Then the third one is the mere discovery of a scientific principle. Fourth is discovery of living or non-living things, that is also not patentable. But agriculture or horticulture, any agriculture or horticulture method is also not patentable. And sixth is new form, property, use of a known form of substance, also not patentable. For example, here we can say if any drug or any composition herbal composition is available in market, or do a few changes in that, or if take the position, then that will also not be possible, and that will also not be allowed by the Indian Patent Office. That the known form of the substantial is mere admixture. If we are taking two ingredients in a composition and it is giving out some known, or that is obvious to the people, then that is called a mere admixture. So we need what plus 1 is 11, not 2. That will not be considered as a mere admixture, and only then it will be patentable. Otherwise, it will not be patentable. Then the mere rearrangement of the devices or plants or animals or for therapeutic treatment. If we are providing any drug for the use, if we are saying that this drug can be used in this disease, then that use cannot be patentable. Any method of treatment cannot be patentable in India. Now, further, I would like to explain all the processes step-by-step manner that we shall require during our patent basis, such as PatBase, and there are many other databases which we use to find out that which all inventions are already existing in the market. So first, before filing our patent application, we should know that the similar application or the similar idea should not be available in the market, or our invention should fulfill the three criteria of the patent. That is novel, it should be novel, it should be inventive, that is non-obvious, and it should have some utility, and it should be industrially applicable. So in order to assure that our idea is new and the patentability search is required, so that will brief out that what all ideas are already published or patented by someone else. So this is the first step before applying for our invention. So patentability search should be conducted worldwide, not just India. So another thing that I would like to tell, there is nothing like worldwide patent. So patents are territorial rights. If we are filing in India, then we shall get the protection of that within our territory. But when we are doing patentability search, while doing the patentability search, it is to be conducted worldwide, not just India. Now, the second step is drafting and filing of an application. Here, we shall require an expertise or a perfect drafting of the claims of our invention, such that it shall not face much of the objections by the Indian Patent Office. Now, the third step is publication of an application that we have already discussed in the flow chart, that once it is filed, there will be a publication from the Patent Office site within the official journal of the Patent Office. Here, you can see the official journal of the Indian Patent Office, where how the Indian Patent Office published the applications in the journal. Now, there is an option of request for early publication. Even women, if a woman is an applicant in the Indian Patent Office, then they are more preferred. I mean, there will be a fast processing of the patent applications. We can file the request for early publication. Publication of an application can be expedited by the request for publication under Section 11A2 in Form 9. Now, the next step is examination of application. What the examiners will do, examiners will examine our application and they will see all the objections or rejections in an examination report and will be sent to the applicant. Then further, we shall require and reply to the examination report and provide his best arguments such that the examiner or the controller shall be agreed by the reply. Then there will be a grant, either a grant or a rejection of our patent application. This is the complete process that we follow in the Indian Patent Office and in the law firm. Now, there are many other forms of IPR. There are many other forms of intellectual property rights apart from patents, but the patent is the strongest one. And the second one is trademarks. Trademarks is a sign, logo, tagline, expression that distinguishes goods or services. It is used to protect brand of a company. Here I have shown some of the brands, and these are trademarks. Then the another form of IPR is copyrights. We all must have heard about the Bachchan's case. Mr. work, Mr. Harivansh Rai work that was by the poet. And what he did, Amitabh Bachchan used this copyrights. Mr. Amitabh Bachchan used this copyright action, sent him the notice to others, and there are so many issues like regarding the copyright. There is no state for apply for the copyrights. If we have prepared, if our work is original, then we get automatic copyright of that work. For example, whenever we are exposing your data to the third party while installing applications, that is protected under copyrights in a phone. That is a very simple example of a copyright. Then the another form is designs. See, in India, we do not have any designs patent, but we can file design. This designs patent is used in US, and here we can in India we can file design applications. Design protects the appearance or the ornamental features of a product. For example, the design of the circular home button of the Apple iPhone that cannot be used by any other company. That circular button for the circular home button that has already registered under the design under Indian Patent Office. So the another form of IPR is geographical indication. Geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. For example, Darjeeling tea, its word and logo both are under geographical indication. For example, Kolhapuri chappals and many others. Now, the trade secrets. Trade secrets are the confidential information which may be sold or licensed. What qualifies a trade secret? Commercially valuable because it is a secret. It is to be known only to a limited group of persons. So we know that Coca-Cola composition, Coca-Cola has a composition. He can go for filing a patent also. But why did he choose to file a trade secret? Their main reason was that this Coca-Cola company, when they decided that they should have that, they got to know that their invention or their composition shall be objected under Section 3B of the Indian Patent Act. Because under 3B, we know that anything which is harmful to the human body that cannot be patented. This Coca-Cola formula is harmful and can cause the osteoporosis in human body. That is why Coca-Cola has gone to the trade secrets option, and they got their formula under trade secret. A shortcoming of this thing, trade secret, is that it can be leaked. If it is leaked, then there will be no option to protect it. So patents are much better than trade secrets. But another thing is that in patents, we need to disclose our formula, and after 20 years, it shall be in public domain. But in trade secrets can be kept for the lifetime. So there are some examples of other IPR forms. These are copyrights, which includes books, articles, or any literary work. Trademarks, we have already discussed Pepsi, Coca-Cola, and many others. Design rights, ornamental or footwear design, or any kind of features of our phone, or geographical indications, which involves examples such as Darjeeling for tea produced in the Darjeeling area of India, Champagne from France, Trade secrets includes composition of Coca-Cola and Chyawanprash. So thank you very much for giving me this opportunity.
Thank you, ma'am, for a wonderful talk. I
Thank you,
think
ma'am.
for the final year students, that would be familiar with the many terms, and for the first year and probably second year, maybe just get to know. And I think you narrated with the stories, and that just made the talk interesting. So now I would ask Navgeet ma'am for her vote of thanks. And before that, I just want to ask to the students to be ready with their questions so that they can interact with ma'am.
Good afternoon, ma'am. I would like to thank Mrs. Monica Sharma, Patent Facilitator, SIPP, Government of India, Women Scientist Alumni, TFAC, for making out time for our students. Ma'am, your talk was very interesting. Actually, our final year students are already studying this subject regarding patents. And a few information we have shared with the second year students also. And with your talk, we have got elaborative knowledge about the patents. I think this is going to help the students a lot. So I would like to thank you on behalf of the Department of Biotechnology, Kanya Mahavidyalaya Jalandhar, and your talk was very interesting and knowledgeable for the students. So we are very thankful to you, ma'am. We would like to ask you again for the coming sessions of our students, so that they can also get more information from you regarding the patents. Thank you so much, ma'am, for sparing time for us.
Thank you so much, ma'am. Thank you so much. Thank you so much.
So students, do you have any queries? You can ask, ma'am.
Good afternoon, ma'am.
Yes, please.
Ma'am, I have a doubt. Like you said that living organisms are not patentable. So I was wondering if recombinant organisms, are they patentable or not?
There was some network issue, right, on my side.
Ma'am, I'll repeat the question if you want.
Please.
Ma'am, like you said that living organisms like animals and plants, they're not patentable. So I was wondering if recombinant microorganisms, are they patentable?
Yes. See, I told that plants, animals per se are not patentable. Okay. So if there is any human intervention in the sequence or in preparing that invention, then they are patentable. As we have seen the example of human insulin in the Majumdar Shaw's example, there she prepared that recombinant insulin. Okay, in general, that insulin can be easily produced, but problem is that in its natural form, it cannot be patented. And also in its natural form, they have very least shelf life, and that is the biggest problem while preparing for insulin. So anything which involves the human intervention, that is patented.
Okay, thank you, ma'am.
Subjecting to other criteria of patentability, but the inventions, mainly in biotechnology inventions, if there is any human intervention and that is coming with a new product or a new process which is novel, inventive, and industrially applicable, then it can be easily patented.
Okay, ma'am. Thank you, ma'am.
Good afternoon, ma'am.
Good afternoon.
Ma'am, if the applicant has applied for more than one country to apply for the patent, and he also get accepted, then then will he have the chance to choose which country he want to get patented?
Yes. There are a few options that if an applicant wants to apply, suppose in different countries, then there is the best way of filing is PCT filing. That is Patent Cooperation Treaty filing. Under PCT filing, we can file in multiple number of countries by a single application. Am I clear?
Yes, ma'am.
Girls, anyone else having any query? You can ask.
Monica ma'am, just I want to add, if you can tell students how they can be a registered patent agent, how
Yes,
they can
yes,
make a career.
Sure. Yeah, actually, I'm also preparing students with this patent, the upcoming patent agent examination, which is in May 2022. And due to COVID, it has been delayed. Otherwise, it would have been occurred last year also. So it is very, see, MSc, PhD, we all knows about all these streams and all these career options. But becoming a patent agent, that is a very beautiful career if I suggest. Matlab, personally, I suggest that this is very good branch where we can use our intellectual also, and we can make our business also, and further we can become an independent patent consultant also. So if there is a examination that is open from the Indian Patent Office, which is conducted every year, and anybody after completing his bachelor's in science can apply for the patent agent examination. And once they qualify, there is a particular format of the examination, and once they qualify, they become registered with the Indian Patent Office, and they can itself file the patent applications, and further can go into the litigation, prosecution, or any patent searching firms, law firms, and anywhere there is a vast career options after completing patent agent examination and getting registered with this Indian Patent Office. And also there are startup facilitator schemes that patent office brings out for all the students or all the patent agents. After becoming a patent agent, you can go and apply for a startup facilitator, where you can help out and work with the Indian Patent Office with the various new upcoming startups also, and you can provide support to them also. I hope I'm clear.
Yes, ma'am.
So do any student want to say something, ask something? Especially the final year student? Or the first year students? Do you have any query?
I think so. No other student is having any query. So, ma'am, it was a very nice talk. I would like to again thank you
Thank
for
you
your
so much,
precious
ma'am.
time.
Thank
Thank
you.
you so much,
It was
ma'am,
too.
for
It was
sparing time
very
for us.
nice. It was very nice to see all the women, and happy Women's Day also. So it was
Thank you,
really nice,
absolutely.
really nice. Thank you so much.
Thank you so much, ma'am.
Actually, I was very excited to deliver talk here. I have delivered talks in many colleges, but seeing women Kanya Vidyalaya, so I was really excited when Gurpreet ma'am told me. Then I was very excited to deliver. Thank you so much. Thank you so much.
Thank you so much, ma'am. Thank you.
Okay.
Okay, thank you so much, ma'am, for your time.